Greetings to all of you. So today's lesson we are going to start with the second unit's revision, which is on the incorporation of a company. Incorporation of a company is another area which has been highly questioned in the past. If you have done a past paper analysis, you would notice that even incorporation of a company is an area which is touched in all questions, section 1, section 2 as well as section 3 questions. So thereby a very important lesson, I would say, is the incorporation of a company. The lesson is divided into several areas, starting from the different types of companies that you ought to know for the exam. Moving on to the incorporation part of a company, the documentation that is required. Thereafter we are going to who starts a company, the promoters and the promoters' duties and the payments to the promoters. We are also going to discuss about the articles of association of a company, which is like the backbone or the constitution of a company which governs how a company is being administered. So those are the main 4 areas that will be covered in today's lesson. There will be a lot of important areas I have added in the note as well. So make sure that you have the note with you so that you can highlight whatever the important areas are. Everything is not included in the note because this is only a revision series. Only the parts that are usually questioned at the exam have been added in the particular revision series. The set of slides will be helpful for you in the recognition and the identification of the important areas, but other than that, what you need to know, the theory part that you need to know, is in the document that has been shared with you as the revision note. So before we start with the incorporation of a company, first and foremost what we ought to know or what we ought to understand is what is a company and what are the different types of companies that you could incorporate, because based on the type of company that you would want to incorporate, the incorporation procedure, incorporation documentation would be different. So therefore, first and foremost we have to identify what are the different types of companies, and thereafter on identifying what are the different types of companies, we can move on to the incorporation procedures and the documents. So under incorporation of a company, first lesson is on how the companies are being divided into. This is a diagram I have taken from your study text itself, because this will give the crux of the companies that you ought to know about. So under the Companies Act number 7 of 2007, these are the main types of companies. So there are 2 sections that speaks about the different types of companies. We have section 3A and section 3.1 and section 3.2. So under section 3.1, there are 3 companies that have been recognized: the limited companies, the unlimited companies, and the companies limited by guarantee. Even companies limited by guarantee are limited companies, but they are limited by guarantee and not by shares. But on the other hand, when we take these limited companies, mainly they are limited by shares. So under limited companies, again there is a further classification under section 3.2 as private companies and offshore companies, but this is a classification, further classification of limited companies itself, Now in this particular lesson, we will be focusing of course on we'll be focusing on limited companies, the 2 types, public limited as well as private limited. Unlimited companies will be focused on. Again, private companies I'll be giving you a definition, as well as offshore companies will be giving you a definition. But companies limited by guarantee are not that much important in this particular lesson, because separately we will have another lesson where we are going to focus on companies limited by guarantee. But here we are going to mainly focus on these 4 different types of companies only with regard to their classification. So in this particular lesson, under the classifications of section 3.1 and 3.2 of the Companies Act number 7 of 2007, we will be discussing about limited companies, both private limited as well as public limited, unlimited companies and offshore companies, right? So first itself, we are going to start with limited company. So under limited companies, in the note I have given you, a limited company is a business that is owned by its shareholders, run by the directors, and most importantly, whose liability is limited. So 3 features of a limited company have been given there. 3 features of a limited company have been given there. Most important first feature is the limited liability. Most important first feature is the limited liability has been given there. Very, very important. You have to understand that limited companies means there should be limited liability. That is the first feature of any limited company. Second thing is, I explained this to you in the first unit as well under the revision. Usually their management and the ownership is separate. Ownership and management is usually separate. The ownership and management is separate. Then only these two are the main two features of a limited company. Usually owners are the shareholders, whereas managers are the board of directors and the management usually. So they are doing the management of the company. So a limited company is a business that is owned by the shareholders, run by the directors, and they have to have limited liability. Only if they have limited liability that they will be called as a limited company. Limited liability means that the investors can only lose the money they have invested and no more. This also I have explained to you in the first revision as well, in the first lesson's revision, that maximum that the shareholders will lose in a limited company is the amount they have invested in the company. Maximum they will lose is the amount that they have invested in the company. This is the same example I gave you before also. Let's say I buy 100 shares of a company. Each share is worth 100 rupees. Maximum I have invested in the company is 1000 rupees. Maximum I will lose is this 1000 rupees and nothing else. Maximum I will lose is this 1000 rupees and nothing else. That is the meaning of limited liability. In terms of section 89 of the Companies Act, once the shareholders have paid for their shares, the company cannot increase their liability to the company or compel them to take further shares in the company without their consent. Now what does that mean? Sometimes, now when you take the share capital, in the next third unit's revision also I will explain this to you. There is something called paid up share capital and unpaid share capital. Now let's say out of this 1000 rupees, for example, let's say as of now I only have 800 rupees. I only have 800 rupees. So I tell the company, look here, I'll give you 800 rupees, but I will purchase all 100 shares. I will give you 800 rupees and purchase all 100 shares, meaning I still owe the company 200 rupees. I still owe the company 200 rupees. At a point of liquidation or at any point, company can ask me for this 200 rupees only. That is the amount that I have still not paid to the company. The amount that I owe to the company. That amount the company can ask from me, but nothing more. So you can see, even if you take the addition of this 800 and the 200, maximum is 1000. Maximum I will lose is the 1000 rupees that I have invested in the company, nothing else. Company can't force me to buy further shares, or company can't force me to increase my liability, or company on its own also cannot increase my liability. Only thing that the company can do is to ask for this. If there's any unpaid money on the share capital, that amount can be claimed and nothing else. Very, very important point. So basically there are two types of limited companies. I have given it to you here. There are private limited companies as well as public limited companies. There are private limited companies as well as public limited companies. Each of them we are going to discuss separately. So public limited companies. What is the main difference between a public limited company and a private limited company is that in private limited companies, it's a smaller circle of shareholders. Maybe family members, maybe friends, just a few people who know each other. Shares cannot be issued to the public in a private limited company. But on the other hand, when you take a public limited company, shares can be issued to the public. So therefore, you can easily raise capital, you can issue shares, even the public can buy the shares. That's the main difference between a private limited company and a public limited company. I've given you there. Limited liability companies which are listed in the stock exchange are known as public limited companies. I have taken that definition from your study text, but that is not quite right, because when you take public listed companies also, some of the public limited companies will be listed companies or are the quoted companies, right? Listed companies. So listed companies are public companies, but it is not a must that all public companies are listed companies. But in general, even if you take the normal procedure of public companies even in Lanka, majorly they sell shares to the public through the stock market. So usually because you can sell your shares to the public in the stock market, we call them as public limited companies at large. But actually the correct name for companies that are selling their shares in the stock market is the term listed companies. Listed companies are also public companies. Companies incorporated under the Companies Act number 7 of 2007 or any other statutory corporation incorporated or established under the laws of Sri Lanka or established under the laws of any other state subject to exchange control approval are eligible to seek a listing on the Colombo Stock Exchange to raise debt or capital or debt or equity. So as a public limited company, once you incorporate a company under Companies Act number 7 of 2007, you have the right to have a listing of your shares in the Colombo Stock Exchange. Not only companies that are registered under Companies Act number 7 of 2007, even if you are a company that is incorporated or established under any other laws of Sri Lanka, you know, sometimes through Parliament Acts, some of the companies are being established. So those companies also can have their listing in the Colombo Stock Exchange if required. Other than that, a company that is established under the laws of any other state or any other country also can get their listing in the Colombo Stock Exchange as long as exchange approval has been given, as long as exchange control approval is being given, especially if it is a company belonging to another country or established, registered in another country. So that is the people who can go to the Colombo Stock Exchange, right? People who can, not the people, the companies that can have a listing in the Colombo Stock Exchange. Not very important, rough idea is enough. Shares of a public limited company, also known as public quoted company. So usually I told you we call them listed companies or quoted companies. That's the term. Can be purchased by any member of the general public through a licensed stockbroker. Any person, even you and me, who want to invest in any company shares in the Colombo stock market, we can purchase shares of the Colombo Stock Exchange. Usually you do it through a stockbroker. So you can purchase shares just like, you know, now just like we have markets for any other products. The share market is the market for shares where people can, you know, prospective sellers let's say sellers of the shares meet prospective buyers of shares at the stock market. So therefore in Sri Lanka, the main stock market that we have is the Colombo Stock Exchange, and therefore anyone from the public, you, me, anyone from the public can go to the stock market and purchase shares, through the stock market can purchase shares of any public limited company, or rather quoted company, of a listed company or a quoted company. If we want, we can do it through a licensed stockbroker. Public limited companies are carefully scrutinized and monitored by the Securities and Exchange Commission and the Colombo Stock Exchange. CSC is Colombo Stock Exchange, as the shareholding of these types of companies are held by the general public. Very, very important point. Out of private limited companies and public limited companies, what are the companies that are mostly regulated by the government, or what are the companies that are undergoing a lot of regulations? Is the public limited company. Most scrutinized is the public limited company. Why? In a private limited company, even if the company collapses, just a group of people from society will lose what they have invested in the company, in a private limited company. But on the other hand, when you take public limited companies, it is not so. In case if a public limited company collapses, it will affect a majority of the public. Therefore, government is very, very interested and bothered to find out what is really happening with regard to public limited companies. So therefore, the Colombo Stock Exchange, the Securities and Exchange Commission, everyone is always on the lookout with regard to public limited companies, especially the listed companies or the quoted companies. After that, I have given you public limited companies, unlike private limited companies, are expected to adhere and comply with the Code of Best Practice on Corporate Governance. Not only laws, so laws are having an impact on them, not only laws, even ethics, or we call it corporate governance. There are corporate governance implications also on public limited companies. There are corporate governance implications also on public limited entities. Why? As I told you before, in case something happens in a public limited entity, or rather quoted company or a listed company, it will affect the entirety of the public. Right? Therefore, the governments are very, very bothered about what is happening in public limited companies because it will impact the entire public, which is not a problem when it comes to private limited companies, because that is it's just a group of shareholders. If at all something goes wrong, only that particular group or small number of people in the society will be affected. Those are the main reasons. Right. Now let's go to the requirements with regard to a private limited company. We are still identifying the different types of companies. The fundamental rule in a private company is that its shares should not be offered to the public and its shareholders should be limited to a maximum of 50 shareholders. So usually private limited companies have a smaller circle compared to public limited companies. Public limited companies can have a lot of shareholders, whereas private limited companies just usually have a handful of shareholders. Maximum they can only have 50 shareholders. That 50 shareholder mark is important, have been questioned in the past, will be questioned in the future. So maximum number of shareholders that a private limited company can have is 50. The Companies Act number 7 of 2007 has granted private companies a considerable degree of informality by recognizing the unanimous agreement of shareholders under section 31 of the Act to dispense with formalities in major transactions of the company, such as the issue of shares or making distributions. That is why I told you, usually when you take the governments or the law, they are most likely bothered about public limited companies more than about private limited companies. So therefore, a lot of regulations are lessened when it comes to private limited companies as opposed to public limited companies. Public limited companies have a lot of laws, regulations that are governing them. But when it comes to private limited companies, lesser rules. Now even earlier, there was a requirement that there is a court approval procedure whenever important decisions are taken in the private limited companies. But under Companies Act number 7 of 2007, under section 31, it says in a private company, if there is unanimous shareholder approval, what is unanimous shareholder approval? 100% shareholder approval. If all the shareholders of the private limited company agrees, you can dispense with the formalities, the usual formalities that are required, court procedures that are required with regard to major transactions like issuing shares, making distributions. You don't have to fulfill the major formalities. If there is unanimous approval, that is all shareholders agree, you can do what the shareholders want. Because as I told you earlier, public companies, it is not so. For public companies, for every minute nitty-gritty, there are major laws, rules and regulations. But in private companies, it is not so, especially if the shareholders are in unanimous agreement, we give them to do whatever they want, even with regard to major transactions in the company, because a major public will not be affected by a decision of the private companies. After that, I have given you specifically, it allows a company to dispense with the keeping of an interest register if there is a unanimous resolution by all its shareholders to do so. So, usually companies have to maintain an interests register that is not required for private limited companies. If all the shareholders, if there is unanimous approval or 100% shareholders agree that they don't want an interest register, then you don't have to have an interest register. You can just move on with the company as the shareholders will, right? Without really court approval or more rules and regulations from the side of the government is not there when it comes to private limited companies. More discretion to the shareholders in private limited companies. Private limited companies are generally used as startup companies which hope to evolve into public limited companies. So that's usually why people start private limited companies, because actually the amount of capital you can collect is quite restricted in a private limited company. So one might say, why would anyone want to start a private limited company? Straight away starting a public limited company is not easy. Usually what people do is they will start with a private limited company. Little by little, they will evolve it into a public limited company. Starting as a private limited company, little by little, they will evolve it into a public limited company. Usually, even majority of public limited companies, starting off their life have been as a private limited company. Then only they convert into public limited companies. They are also ideal for business models which require power to be centralized in a smaller group of individuals, especially if we want the power to be in the hands of a less number of people, without power being, spread across, right? If we want the power in the less amount of people's hands, then you can go for a private limited company, because if you go for a public limited company, so many people from the public have invested in the company, so all of them will have an impact on the decision making, or rather, especially if you are a majority shareholder, you can have an impact on the decision making. But in private limited companies, decision making is in the hands of a few number of people. Usually majority of private limited companies that even we incorporate as company secretaries, usually the shareholders themselves end up being the directors also. So the decision making and everything is in the hands of one and the same group. So this particular part can be sometimes affected, this management and ownership being in two separate hands. But always this is the case when it comes to public limited companies. Ownership and management is separate, because all the shareholders can't end up being the board of directors in a public limited company. So that's about the definitions, the main differences between a private limited company and a public limited company. Now, what are unlimited companies? This is a very different type of an approach. Unlimited companies. Why? Usually, why would people go for a company instead of a sole proprietorship or a sole tradership or a partnership? Question is, why would people in general prefer to go for a company over and above a sole proprietorship or a general partnership? Main reason is because of the limited liability. In a company, you have limited liability and people like the limited liability. No one of us like to take, a big amount of burden or a hassle on our head. So we like to go for a company because we have limited liability. But in this unlimited company concept, that limited liability concept in itself has been removed. In an unlimited company, the limited liability, which is the selling feature of a company, is being removed. So therefore, many scholars have come up with different definitions for unlimited companies, but this is a very rare type of a business enterprise. Unlimited companies are companies where shareholders are liable to contribute to the company without any limit. That is, in the case of company failing to pay its debts, shareholders' personal estates may be used to satisfy the company's debts. So completely the unlimited concept has been removed. In case if the company is unable to pay its debts, shareholders will have to sell their personal assets and settle the debts of the company, just like in the situation of a sole proprietorship or a general partnership. So that is the meaning of a unlimited company. So we have discussed under limited companies, private limited companies, public limited companies and unlimited companies. Next, companies limited by guarantee, right? So not much that we are going to discuss about it, just a rough idea on the companies limited by guarantee. What are companies limited by guarantee? These types of companies do not issue shares, but the members are bound by the articles of the company to contribute in an amount specified therein if the company is liquidated, right? So here also we have to understand it's a limited company. Still, it is a limited company, but limitation can be in two ways. Limited can be either by shares, limited can be by shares or by guarantee. Limited can be by shares or by guarantee. So earlier what we discussed, private limited companies and public limited companies are usually companies limited by shares. Now this limited company is a company limited by guarantee. How much is the guarantee of each member? We can't call them shareholders, we call them members, because there are no shares in a company limited by guarantee. So we call them members. So the amount that a member guarantees to pay in the event of liquidation will be mentioned in the articles of association of the company, and the members will be bound to pay that amount that is mentioned in the articles in case of a liquidation or the company is unable to pay its debts. The amount that the guarantors, or rather the members, will have to give for the limited companies limited by guarantee is only the amount they have confirmed, or only the amount that they have said that they will contribute, only the amount that they have said that they will contribute. if the company is liquidated only, that amount has to be given. These companies are suitable for charities and non-profit organizations. Usually what start as guarantee companies are charities and not-for-profit organizations. Usually profit-seeking organizations don't start as a guarantee company. This company is given the opportunity of dispensing with the word limited from its name. Now earlier we know if you take public limited companies or private limited companies, having limited at the end of their name is very important. How do we use this limited term? We will come to it later. But having the limited term at the end of their name is a must for private limited companies and public limited companies. But when it comes to guarantee companies, it is not a must. If you want, you can get away with this term limited. Now usually when you take the UK law, they have to have the term CIC at the end. But those regulations are not there in Lanka. It's not a must for you to have the term limited at the end of the company name in a company limited by guarantee. Then moving on to overseas companies. An overseas company means any company or body corporate incorporated outside of Sri Lanka. What we call as an overseas company is a company or a body corporate that has been incorporated outside Sri Lanka. After the appointed date, establish a place of business within Sri Lanka. So basically, it's a company or a body corporate that is incorporated outside Sri Lanka. Nationality of the company doesn't particularly come as a Sri Lankan company because it is established or incorporated outside Sri Lanka, but at a particular appointed date, right? They have a business premises in Sri Lanka. As of the appointed date, they have established a place of business in Sri Lanka, or has before the appointed date established a place of business within Sri Lanka and continues to have it established place of business within Sri Lanka on the appointed date. So basically, simply what you can remember is when you take an overseas company, these are not offshore, we are talking about overseas companies. Especially the feature of overseas companies is they are established outside Sri Lanka. They are established outside Sri Lanka, but they might have or they will have a branch or they will have an office incorporated inside Sri Lanka as at an appointed date. Even if it has started before the appointed date, as and when the appointed date comes, the place of business should be there in Sri Lanka. Anyway, it is a business corporation that has been established outside Sri Lanka but has a place of business within Sri Lanka. That is what we call as overseas companies. So the laws, regulations that are applicable to these companies will be different, particularly based on the laws, rules applicable will be different based on the different types of companies. Then offshore companies. Now let's see what is the difference between an overseas company and an offshore company. A company who wishes to carry on business outside Sri Lanka can be registered as an offshore company. Now, what we call as an overseas company is it is incorporated outside Sri Lanka, but business is happening inside Sri Lanka. I repeat, in an overseas company, it is registered outside Sri Lanka, but business is happening inside Sri Lanka. Now, that's actually the opposite when it comes to an offshore company. They must have started the business in Sri Lanka, but they are operating outside Sri Lanka. So the tax laws, regulations governing their procedures will be different. It will be different. So they are companies that are maybe incorporated in Sri Lanka, but they are doing their business activities outside Sri Lanka. A company who wishes to carry on business outside Sri Lanka can be registered as an offshore company. This is a company or body corporate incorporated under the laws of any foreign country. So it usually, because it is functioning outside Sri Lanka, it can be, usually it can be incorporated under the laws of any other foreign country as well, because it's incorporated under a foreign country, though sometimes the owners are Sri Lankans, can be incorporated under a foreign country law and functioning in another country or another jurisdiction. Offshore companies offer various advantages which includes reduced tax liabilities. That's why I told you mainly why understanding these different types of companies are important is tax liabilities will be different, how they do their operations will be different, how operations will be affected by laws and regulations will be different. This is a company or body corporate under the laws of any foreign country. Offshore companies offer various advantages like reduced tax liabilities and the simplicity of operations due to fewer compliance and reporting requirements. They are not bound by different regulations as in a local Sri Lankan company. That's a offshore company. Moving on to single shareholder companies. About single shareholder companies also we have discussed under the first unit's revision as well. The original bill presented to Parliament contained a provision to the effect that a company may have a single shareholder where such single shareholder is a body corporate or the secretary to the treasury. So actually at the beginning, if you were to start a single shareholder company under the Companies Act previously, under even the Act number 7 of 2007, earlier regulation was if you want to have a single shareholder company, that single shareholder should be a representative, a body corporate, or it should be a secretary to the treasury holding shares on behalf of the government. If you are starting a single shareholder company earlier, right, this was the earlier requirement. If you are starting a single shareholder company, that single shareholder should be the secretary to the treasury holding shares on behalf of the government. But later an amendment was brought about that any body corporate or even one person, a single person, a normal natural person can act as a single shareholder of a company, which is the action that is prevalent even today. You can start single shareholder companies. An amendment made at the committee stage in the Parliament has changed that position, permitting even an individual to be a single shareholder of a company. So usually in the lawmaking process there are several stages. We call it the first reading. There's a step called first reading, second reading, then there's a committee stage. There's a committee stage. So at this committee stage only it was decided and they made the amendment to the law. At the committee stage only they decided and made the amendment to the law that even one particular person, a single person, should be able to be a single shareholder in a company. Thereby today the practice is you can be a single shareholder of a company. So those are the classifications of companies. Almost all the companies we have discussed at large. Only companies limited by guarantee wasn't focused much. Anyway, we will be discussing about it again. So we discussed about limited companies. We discussed about private limited companies. Together with that, we also discussed about public limited companies. So with private limited companies, we discussed about public limited companies as well. So we discussed public limited companies, private limited companies, under limited companies. Then we discussed what are unlimited companies. We discussed what are offshore companies as well as overseas companies. Together with that, we studied what are overseas companies as well. And then we also studied a little bit about companies limited by guarantee. And apart from all of this, we also discussed about single shareholder companies. We discussed about single shareholder companies as well, about single shareholder companies as well that we have discussed. So that's about the classification of companies. I'll tell you the type of questions that you get in this particular area at the exam. I have done a past paper analysis at the end of your tute, you can see, but even under the past paper analysis, something that you can focus on is they might give you a scenario. Give you a scenario and say, explain the different types of business organizations, and depending on the requirements of the person that is mentioned in the passage that they have given you, they might tell you to find the most appropriate business organization or the most appropriate type of business organization that will suit the requirements of the person mentioned in the particular passage. So those are the types of questions that can be asked from this particular area. Very rarely that they will ask you for the definitions of these, but you should know when a person tells you the requirements of that person, how do we find a company that matches with such requirements, or how do we find a company that will match with the requirements out of these sets of companies that we have studied about. The next part of the lesson is on the incorporation of a company. So we are going to talk about the theory aspects of it as well as the practicality, because they might sometimes question you on the practical aspect or the stages one by one as to what we usually, because those days how we used to do work at the registrar of companies, incorporation of a company was different to the procedure today. So therefore sometimes can be, because the procedure changed quite recently, you can't say recently but quite recently, so therefore sometimes they might question you on the practicality as well, right? So as such, we'll be discussing about the theory aspects and how it's actually done in practice also. I'll be giving you a small introduction as to how we company secretaries nowadays do the incorporation of a company. The practical aspects also I will discuss with you. Right. So the incorporation of a company, you should know today incorporation completely happens paperless, or it's happening electronically. That's why that is through the 𝐸ROC platform. So we now have a platform called the 𝐸ROC platform. So nowadays all of the writings and everything happens in the 𝐸ROC platform. Happens through the 𝐸ROC platform. So therefore completely paperless. So those days we used to carry heaps and heaps of paper and go to the registrar of companies, which doesn't happen now, right? Because now everything is happening paperless in an electronic format. The prescribed form for incorporation of a company is set out in Form 1. So actually where we begin the incorporation of a company is through this first form called the Form 1. Form 1 will particularly tell what are the details you have to put with regard to the company, particularly the details of your shareholders, how much shares do they have, what is the total number of shares in the company, names of the directors, names of the company secretary, addresses, ID numbers, all of these details about the company in general, name of the company, the registration number, of course, the ROC will give it to us at the point of registration. All of those details, the date of incorporation, all of those details, the day that we passed a resolution in the company, all of those details will be mentioned in Form 1. Form 5 shall be used for incorporation of a company limited by guarantee. So Form 1 is for any other company separate. So it's usually Form 1 or Form 5. But Form 5 is separately, only for Form 5 is separately only for companies limited by guarantee. Form 5 is separately only for companies limited by guarantee. The most common one is Form 1. So Form 1 is for all other companies. Form 5 is for guarantee companies. Form 5 is for guarantee companies. Form 5 shall be used for the incorporation of a company limited by guarantee. The prescribed form consists of the proposed name of the company. So of course this Form 1 will have the proposed name of the company. Now of course under the new electronic system of the ROC, we first get the name approval done. So that approved name will come at the beginning. It will already come typed at the beginning of your Form 1. So those days we used to get, physical copies of these forms, fill them up, get signatures of the directors, shareholders, company secretary and submit. Now it doesn't come like that. When we feed in the details, everything will come in a typed format. So only you have to take a printout, get the signatures, scan it and submit it again. That is how in the practicality today it happens. So anyway, it will have the proposed name of the company, registered address of the company, names and addresses of the initial directors, shareholders. Why do we say initial directors? The Form 1 is not upgraded from time to time. Why do we say initial directors? Because Form 1 will only have details of the first directors, because directors will change over time. Shareholders will change over time. In Form 1, we only have the initial people's names, addresses mentioned, right? Not of the people who changed thereafter. Shareholders, secretaries, all of their details will be mentioned. Those are the main things that you will find in Form 1. The proposed name of the company, registered address of the company, names and addresses of initial directors, shareholders and the company secretary. It also includes a declaration to the effect that to the best of the applicant's knowledge, the proposed name of the company is not identical or similar to that of an existing company. So those days we used to physically fill up a declaration form and submit that. The name we have selected for our company is not used by anyone else, or it's not a name that is used by anyone else. We used to physically, give a declaration form. Now not required. When you are getting the name approval, you are signing up saying that I confirm to the best of my knowledge there is no other company that will have a similar name to the company name that I am using. Why is this important? If you are using a name which is similar to the name of another company, or if it's misleading, or if you are misleading the public to believe that your company is another company, same as another company. For example, let's say I can't go and start a hotel called Hilton. Why? there's already an established business enterprise in that name. I can't go and start a clothes shop called House of Fashions. Why? Because there's already a business that is incorporated under that name. If I put a name that is similar to that name, thinking that people will get misdirected and will come to my business, it is actually called the tort of passing off. It's a tort, right? It's a liability. You can't do that. You can't use a company name which is either identical or very much similar to the name of another company. So to that effect also you usually tick up. We have to tick up in the EROC platform. You have to tick a particular box as the declaration to say that the company name that you are using is not identical to the company name of another company. Now, as I told you, you would understand the one of the most first very important steps of incorporating a company is naming your company or selecting a name for your company. Selecting the name of your company is an extremely important step. Extremely important first step in the registration of a company. Practically today as well as those days is the naming of your company. First you have to get your name right. Very easy to remember this. I usually tell students to remember this in this way. As and when you are born, other than you being discharged from a hospital, the next important step is making your birth certificate. What is the first very most important first information you include in the birth certificate? The name of the child. Same way in a company, for a company the birth certificate is the incorporation certificate. Just like we natural people have a birth certificate, legal persons have a incorporation certificate. So the first piece of most important information mentioned in the incorporation certificate or the birth certificate is the name. Therefore, naming your corporation is very important. So how the name of a company should come, the nitty-gritties, the important legalities you have to know. It will be questioned over and over at your exam. First one, limited company other than a listed company shall end with the name limited or by the abbreviation LTD. So either abbreviation LTD or limited is for listed companies, limited companies other than listed companies, or in other words for non-listed companies, meaning they are public companies but not listed in the stock exchange. For non-listed companies, we end their name using limited or LTD. For private companies, we end their name using PVT LTD. Private companies shall end in the words private limited or the abbreviation PVT LTD. So this, or you can even have private limited. In letters also you can have, that is for private companies. Then other public companies or companies, public limited companies that are listed in the stock exchange will end with PLC, or in other words public limited company, or in other words public limited company. Public limited company. So that's for listed companies. Now basically when you take public limited companies, it can have two ways. No? We know public limited companies can be either listed or non-listed. Public limited companies can be either listed or non-listed. So let's try to make a small short note of this. Right. So we'll try to write it here. When you take public companies, it can be either listed or non-listed. It can be either listed or non-listed. So if it's a listed private company, the name should end with PLC. Listed private company name should end with PLC. Non-listed company name should end with LTD. Name should end with LTD. Then private companies name should end with PVT LTD. With PVT LTD. That is for private companies, right? So this is the naming. This naming part is very important. Sometimes they give you a particular business enterprise. Sometimes they give you a particular business enterprise and ask you to understand or identify how the name should come. So in the past paper analysis that I have done for you, you will come across this as well. So it will be said as to you will have to identify how you are going to name a particular company. You will have to identify how you are going to name a particular company. So therefore, that part is very, very important. That part is very, very important for you to note down. Remember, naming a company is very, very important. You should know how to name a company. Naming a company is very, very important. Easy to remember. For when you take private companies, it's PVT Ltd. Public companies, if they are listed, PLC, Public Limited Company. If they are non-listed, it will come as a limited or LTD. Now, if you take the UK law under the English law, how they name companies is different. So, if at all, if you have learned any other classifications, just remember that other companies, how they name it is different. And here in Lanka, how we name it is different. Just remember, this is the name classification that you ought to remember for the CA exams. Next one, so Companies Act provides that a company shall not be registered by a name which is identical with the name of any other company or any registered overseas company. You can't start a company that has a similar name to a company in Lanka, nor start a company that has a similar name to a company overseas. Now, for example, let's say Nestle is an Indian company. So, you can't start a company called Nestle here in Lanka. Why? Because there is a already established overseas company. So, I have come across situations where some people have, these communications, and some small business organizations in Lanka have named their company or have registered their company as Twitter. Names like that, but these are internationally recognized companies. So, do we think that the international recognized companies will not come in search of the local company? They do. They come forward and say, you have a name which is similar to our company, please do change the name. So, therefore, you have to be very much ready for these situations. So, please don't remember that you cannot start a company that is having a similar name to an already existent company or a company even in Lanka or overseas. A company shall not be registered by a name which contains the word Chamber of Commerce. So, for some words, in using some words in your company, you need to get specific approval from the government. Now, you can't have a piece called Chamber of Commerce in the name of your company, unless the company is a company which is to be registered under a license granted under section 34 without the addition of the word limited to its name. So, you have to get permission under section 34 to remove the word limited. So, basically it should be a non-listed public company. So, if you want to remove the term limited and put Chamber of Commerce instead, you have to take permission under section 34. Without taking a license or a permission under section 34, you can't use words like Chamber of Commerce in naming your company. A company shall not be registered by a name which is in the opinion of the registrar. Same way, you can't start a business organization and call it a university. You can't start another business and call it a department, right? Because these words like department, university, commission, those words show an affiliation to the government. So, if the name that you have selected for your company shows an affiliation to the government, you have to get special approval from the registrar. So, those names come under the opinion of the registrar. Only if the registrar gives opinion, you can use such names. Usually, you can't use words as such. So, showing an affiliation to the government, you can't use terms as such in naming your company. You can't use terms like Chamber of Commerce without taking a license under section 34. In addition, you can't use a name which is similar to the name of another already existent company in Lanka or overseas. Other than that, in naming your company, you should remember how the name of your company ends. You should know how the name of your company ends. A company has a right to prevent its name being used by another company where the name of the company is identical or can be calculated to deceive third parties. The registrar has the discretion to prohibit registration of such names. Once you have named your company, gotten approval for the naming of your company, no other person can use the name of your company. If they do so, you can lodge a complaint to the registrar, and the registrar will make sure that the second company that used your name will have to change their name. So even if you use a company name that is similar to another already existent business or a company, registrar have the right to refuse the name approval, and therefore you will have to find anyway another alternative name. So once you have gotten a name registered for yourself, for your company, that name can't be used by anyone else either. Now that is what I believe is one main difference between us the natural persons and the legal persons. Now our same name can be held by several other people, no? But when it comes to a business, it is not so. A business name cannot be identical, or two business names can't be identical, or can't even be deceiving other people. Right? Can't even be deceiving other people. Now that is another reason why when you take these logos and logos have a color. Simply when I tell you Coca-Cola, automatically you know red and white comes to our mind, because that is the Coca-Cola colors. When we say Pizza Hut, you know the red hat and the logo comes to our mind. So even with those colors, sometimes you can deceive people using, you know, some of the parts of a company name, using their same colors, you can deceive people. So those things can't be done. If your name is deceiving in some way or the other company can take action against you. The other company can take action against this particular company that uses a similar name or a deceiving name. In practice, applications to incorporate a company first begins with an application to the registrar for a name search in order to determine that the proposed name of the company to be incorporated is not identical or similar to any other existing company. As I told you, in practice, actually the incorporation begins with the name approval. You have to do a name search. Today, if you go to the EROC platform, you have to do something called a name search. After you get approval for the name, they will give you a name approval number. EROC will provide a name approval number. Using that name approval number only, you can incorporate the company. So therefore, first stage of incorporating a company today practically is naming the company. The name approval number will be provided. So once you do a name search and get approval for your company name, you will get a name approval number. That name approval number should be used in the incorporation of the company. So about naming the company, you should know how the name of a company ends, and you should know what are the specific rules, like you cannot use a name that is similar to another company name or deceiving the public. You can't use terms like Chamber of Commerce without a Section 34 license. You can't also use a name which requires the opinion of the registrar, which needs the opinion of the registrar, and incorporation starts with naming of the company. Thereby we go to the particular incorporation of the company. Thereby we go to the particular incorporation of the company. Any person or persons may apply to incorporate a company other than a company limited by guarantee. So for companies limited by guarantee, this procedure is different. So that being kept aside, for any other company, any person can go and make an application for registration. By making an application for the same to the registrar in the prescribed form signed by each of the initial shareholders. So there's a particular prescribed form. According to that form only, you can do the registration procedure. The form should have the initial shareholders' signatures together with the other documents that we are going to discuss now. So usually in form 1, you need to have the signatures of the initial shareholders. So I discussed this with you under the first unit as well. Earlier we had a memorandum of association. This memorandum of association requirement is removed, and there came the form 1 application requirement. So first you have to have a declaration stating that to the best of such person or person's knowledge, the name of the company is not identical or similar to that of a existing company. So with your form 1 or the application for registration, you have to say that, you have to give a declaration that your company name to the best of your knowledge is not identical to an already existent other company. You have to give a declaration saying that your company name is not identical to the name of any other company incorporated. Together with that, you have to give the articles of association of the company if it is different from the articles set out in the first schedule here too, in the sense the Companies Act, and signed by each of the initial shareholders. So you have to also provide articles of association of the company. That is, if you are not going to use the model articles that are given in the Companies Act first schedule, if you want, you can use the articles of association given in the Companies Act first schedule, Companies Act number 7 of 2007 in its first schedule, or you can make your own articles of association and get it again signed by the initial shareholders. Again, who signs the articles of association is only the initial shareholders. All shareholders who join thereafter will not be signing the articles of association, though they will be bound by the articles of association. About that we will discuss later under articles of association. So first you have to give a declaration about the name being similar, name not being similar with any other company, and also you have to give the give the articles of association signed by the initial shareholders. Then you have to give the consent form of each of the initial directors under section 203 to act as a director of the company. So all the directors, all the first directors of the company have to fill in a consent form that they agree to act as directors of the company. Have to fill a consent form that they agree to act as directors of the company. Have to fill in a consent form that they are agreeing to act as directors of the company. How does the consent form work? We will come to that. And the consent from the initial secretary. So of course the shareholders sign the form 1. Shareholders also sign the articles. Directors have to give a consent form that they are agreeing to act as directors of the company. The company secretaries also have to give a consent form that the company secretary is willing or is willing to accept to act as the company secretary of the company under section 221, right? So these section numbers are not important, but the documents are important. Declaration that your name is not similar to that of another company's name, that is the declaration. Second is the articles of association. You have to also give that the articles of association are submitted with the signatures of the initial, with the signature of the initial shareholders, consent form of directors, and the consent form of secretary. So I listed it down thereafter, right? Upon receipt of the properly completed application for incorporation, registrar shall enter the particulars of the company on the register and assign a unique number as its company number. So once you go and hand over all the documentation, what are the documentations? We are going to list it down again later. Once you go and hand over all of these documents, consent forms, articles, declarations, form 1, everything, when you go and hand over to the registrar, registrar will check all the, this is company registrar, registrar of companies will check all the documentation, and if all the documentation is in order, it will enter the particulars of the company in the registers and issue a company registration number or a unique number as the company number. You would have seen this. We call this the PV number. You would have seen this now in different companies. If you have ever done any company work, it's coming as a PV number. Now, the new numbers are coming as a PV number. So that number will be assigned by the registrar. Registrar shall then issue the certificate of incorporation. As I told you, always, compare with the registration of a child's birth. When you go to, register the birth of the child, you can't tell the person at the counter, put any name you want. If you feel it's a girl, put that it's a girl. If you feel it's a boy, put that it's a boy. You can't say that. You have to give the particulars. You have to inform, right, what type of, is it a girl or a boy, the name, place, birthplace, address, mother's name, father's name, those details have to be provided. So is it for a company. So once you submit all the required details as these documentation, then the registrar will issue the certificate of incorporation, which is like the birth certificate of a child. So certificate of incorporation is the birth certificate of a company. Necessary ingredients in the certificate of incorporation. What are the things that will be mentioned in the certificate of incorporation? Name and the number of the company. The name of the company and the PV number of the company will be mentioned. the date on which the company was incorporated, the birth date. Now in the birth certificate the date of birth is mentioned, no? Same way in the incorporation certificate the birth date of the company will be mentioned, and whether the company is a limited company, an unlimited company, or a company limited by guarantee. So whether it's a limited company, unlimited company, company limited by guarantee, those will also be mentioned, and whether the company is a private company or a public company. Then whether the company is an offshore company or whether it's a company, you know, having its work happening in Lanka itself. Company has been incorporated under the Act on the date specified in such certificate of incorporation. If they give you a scenario and tell you to find the day that the company came into existence, it is the date mentioned in the articles of it is the date mentioned in the certificate of incorporation. It is the date mentioned in the certificate of incorporation. That's the birth date of the company. So again, just to finalize, forms that you need to submit for the incorporation, following prescribed forms and documents must be perfected for incorporation of a private limited company. So even any one of you, if you become a company secretary any day in the future, usually majority of companies that come for registration are private limited companies. So what are the documentation you should submit? First thing, of course, the name approval. Nowadays, before doing the name approval, you can't proceed to do a company incorporation. So the name approval is important. Then these form numbers are important. These form numbers are important. Form 1, that's the application for registration of a company. Then form 18, I told you consent of the directors is called form 18, consent and the certificate of the director. So let's say if you have 5 directors in the company, you will have 5 form 1s. Right? If you have 5 directors in the company, you will have 5 form 18s. Form 1 is 1 for the company, but if you have 5 directors, there will be 5 director consent forms, that is 5 form 18s, and form 19 is the consent certificate of the secretary, that the secretary is willing to act as a secretary, and together with that you have to provide the articles of association as well. So the main documentation is name approval important. Form 1 is important, which is the application. For one company there will be one form 1. Then form 18, that is the consent certificate of the directors. If there are 5 directors, 5 consent certificate, that is 5 form 18s. Form 19 is the consent of the company secretary. Form 19 is the consent of the company secretary. Usually in a company there will be one secretary, so then one form, but if you have more than that, more than one should be submitted. Along with that, the articles of association, which is signed by the initial shareholders. Upon submission of the aforementioned documents and relevant payments, so of course there is a payment involved. Higher the number of directors, you will have to pay a higher amount because then you have to submit so many form 18s. Per form 18 there is an amount, simply let's say 1000 rupees. So of course if you submit 5 form 18s, there itself is 5000. So therefore you have to pay according to the relevant charges, according to the officials that you have in your company. If the registrar of companies is satisfied that all requirements have been fulfilled, the incorporation certificate will be issued. So after everything has been fulfilled, certificate of incorporation will be issued, which is the birth certificate of the company. It will have the name of the company, the number of the company, registration number of the company, the date that the company came into existence, whether it's an offshore company, private limited or a public limited company, unlimited company, all those details will be mentioned. That's about how you incorporate a company and the extremely important documentation that you need to remember with regard to incorporating a company. With that, the first part of the second unit's revision is over. There is another part where we are going to discuss about the promoters and the articles of association. I'll meet you on another day with the recording with regard to the revision of promoters as well as with regard to articles of association, rules with regard to articles of association, and about the promoter's duties. We are in the second part of the revision series today, the second part of the second unit under incorporation of a company. In the previous session, we discussed about the different types of companies. Together with that, we also discussed about the incorporation of a company from the name approval up until the documents that need to be submitted. Today we will be discussing about promoters. These are all coming still under the second unit about promoters. We will be moving on to discuss about the articles of association, the legal effect of the articles of association, and the different types of contracts that a company can enter into. We'll start with promoters today. So who is a promoter? Promoter is a person who acts for the interest of the company until the incorporation of the company, or who does the work in the process of the incorporation of the company is whom we call as a promoter. One who undertakes to form a company with reference to a given project and set it going, and who undertakes the necessary steps to accomplish that purpose. So the person who works up until the incorporation of a company, or the person who works for the incorporation of a company, is called a promoter. This definition has been given in the case of Twycross versus Grant. In case if they ask for case laws, you should remember these names. Separate document will be shared with you with the case facts of these cases, the cases that you ought to remember. Does not include any person by reason of his acting in a professional capacity for persons engaged in procuring the formation of a company. For example, I am a legal expert. Someone comes to me to get legal advice with regard to the incorporation of a company. I give that person legal advice in my professional capacity. I give that person legal advice in my professional capacity, and therefore my obligation ends there. I will not be a promoter of that company. I will not be a promoter of that company. My obligation ends there. If I am just only giving professional advice with regard to the incorporation of a company, that doesn't make me a promoter. A promoter typically is responsible for raising capital, targeting initial leads, and chasing initial business opportunities, entering into initial contracts for the formation of the business, and incorporating the company. So those are the main duties of a promoter. Of course, it is something that they can question you on the duties of a promoter. So you need to have a very good idea, or rather very good clue how the promoter works. So basically, promoter will enter into any contracts on behalf of the company before its incorporation. It will target the leads and chase business opportunities for the company, and work up to the incorporation of the company. Those are the work done by a promoter. Next important one is, what are the duties of a promoter? It can be highly questioned. At the exam, they can ask you for the duties of a promoter. Now, if you have done a past paper analysis, you would understand promoters are not a highly questioned area over the past. Meaning, in this exam that they will be giving, most probably they will have a question on promoters. So therefore, having a good focus on the promoters is important. A promoter must not make any secret profit. That's the main duty of a promoter. A promoter must not make a secret profit. One of the main duties of a promoter is that the promoter must not make a secret profit out of the promotion of the company. What is not permitted is making a secret profit, that is making profits without disclosing them to the company and its members. So even if a promoter makes a profit, if the promoter discloses the profit, then it's not a secret profit. What the promoter can't make is a secret profit. We don't say that the promoter can't make a profit. Of course, promoter can make a profit, but if the promoter makes a profit and if it is disclosed, no problem. But if the promoter does not disclose a secret profit or does not disclose a profit, then it becomes a secret profit. Promoters are not supposed to take secret profits. Promoters are not supposed to take secret profits. That's the first important one. I'll just simply give you a scenario, or try to explain to you a scenario to explain what is a secret profit here. Now let's say company wants to buy a building. Let's say company to incorporate the company, start the company, you need to have a premises, no? So company needs to buy a building. And to buy the building, let's say the promoter, now there's no company as yet, so the promoter speaks to the seller. Let's say this is owned by A, so the promoter speaks to a person called A to purchase this particular property on behalf of the company. Let's say A asks for, example, 5 million rupees for this property. Let's say A asks for 5 million rupees. So this is the sales price. This is the sale price. This is the sale price of the property. A asks for 5 million rupees. Now, promoter goes and tells to the, now still in the process, the company that is in process, company in process. So the promoter is only carrying the message. Promoter goes and says that this property is 5.5 million. informs that this property is 5.5 million. Why does the promoter inform that this property is 5.5 million? The promoter is trying to keep a profit of 5 lakhs for himself. Promoter is trying to keep a profit of 5 lakhs for himself. Now, is the promoter supposed to do that? No, that's the most important thing that you have to remember. You can't make secret profits out of the company. Promoters are paid for the work that they do for the company. How are they paid? We are coming to that later. So therefore, you can't make any more or further secret profits out of the company. In case the promoter fails to disclose the profit made by him in the course of promotion, or he knowingly makes a false statement in the prospectus whereby the person relying on the statement makes a loss, he will be liable to make good the loss suffered by that person. So in case, let's say, promoter makes a secret profit made by him in the course of promotion, or he makes a false statement which someone else have to undergo a loss because of the promoter, promoter will be personally liable for those debts. Why? Now, though the promoter works for the company, company is still not incorporated. As the company is still not incorporated, promoter is not having limited liability. In case someone undergoes a loss because of a false statement made by a promoter, or the company that is being incorporated undergoes a loss because of the promoter, like the promoter makes a secret profit, promoter is supposed to pay it back to the company through his own personal funds. He has to make good the losses that other person have suffered, or the company that is in process of making suffers. Promoter has to personally give the money for the company or to that other person. So that's another duty of the promoter. First thing, promoter should not be making a secret profit. If the promoter makes a secret profit, promoter has to give it back to the company, right? If a promoter is caught for making a secret profit, promoter will have to give that money back to the company. Next one, payment of promotion costs and the services. Now, of course, promoters are not working free of charge. No one can be expected to work free of charge. No, promoters are also, they should be paid, and they do some promotional activities. There are costs and expenses there. Who is going to bear all of that? Methods are being used to reimburse a promoter. So what are the methods that are being used to reimburse a promoter? Payments clause is included in the articles of the company, permitting the payments to a promoter for costs and services rendered by him. However, the promoters have no right to compel the company to effect such payment. If required in the articles, when drafting the articles for this proposed company, promoter can tell to include in the articles that this amount of money have to be reimbursed to the promoter. But even if promoter puts it in the articles, promoter have no right to force the company to enter those details, or have no duty to, or have no right to force the company for the company to make payments to him. So actually, this being in a promoter's position is quite risky, because your payment is not guaranteed from any place else. Of course, if you want, in the incorporation procedure, you can say to put your fees also under the articles of association. If the company does so, then no problem. But issue will come if the company does not do so. Promoters are given the option to buy a specified number of shares from the company at the nominal value within an agreed period of time. Sometimes promoters are given an option to be a shareholder, to buy shares of the company at a nominal value, not at the market value, at a normal nominal value, so that at the time that the company opens, if the market value is higher than the nominal value, promoter can sell the shares and make a profit, because promoter is given shares at a nominal value. And sometimes when you start the company, price would have increased, market value would have increased. So this increase is the profit of the promoter. So promoter can take that profit. Sometimes that opportunity is also awarded. The promoters may be allowed to make a profit by entering into transactions with the company and thereby cover the promotional costs incurred by such promoter. But in such event, a proper disclosure of the profit is an essential requirement. Now, actually, promoter can do something of like this sort also. Now, here the property is sold at 5 million. Promoter tells the company, yes, property is sold at 5 million, but to buy this property, I had to incur some expenses, thereby I want 5.5 million. That is 5 million for the property, another 500,000 for me. But can he keep it as a secret? Keeping it as a secret is the problem. You can't keep it as a secret, right? You can disclose the secret and take a profit. That's all. Right. So those are the ways how promoters are usually paid. So that's about the payment of promotion cost and for other services of the promoter, how payments are being done. So usually being a promoter in a company is not a very secure position, especially with regard to your payments. So therefore, if you are a promoter of a company, you should know what are your duties, responsibilities, and how will you be paid for the work that you perform in the company. So promoter's part is a very small part, but questions can be asked. So therefore, have a focus on that. The next important part in the second unit after promoters is on the articles of association. The articles of association is very, very important. Sometimes it might not be very clear with the background. Don't worry about it. Whatever that you need to have is mentioned in the note. Contents of the articles of association. What are the things that are mentioned in the articles of association? Remember, articles of association is the backbone of the company. Articles of association is the backbone or the constitution of the company. Even a country has a constitution. What does the constitution do to a country? It will tell how the country is governed. Same way, articles of association is the constitution or the backbone of the company. It will specifically state how the company is to be governed. The articles of association of a company refer to a document that specifies the regulations for a company's operation. Section 13 of the Companies Act, the articles of association of a company may provide for any matter not inconsistent with the provisions of this act other than the first schedule hereto, and in particular may provide. So usually there is no specification as to articles of association have to provide these requirements is not mentioned anywhere. You can include in your articles whatever you want. You can include in your articles of association whatever you want. But the important thing that you need to remember is under section 13 of the Companies Act, 3 most important requirements of the articles of association have been given. So those 3 have to be fulfilled. There is no option. First one is objects of the company. For what purpose are we establishing this company? What is the work that this company is going to do? Have to be mentioned. Rights and obligations of the shareholders of the company. What are the rights that shareholders have towards this company? What are the obligations that shareholders have towards this company? Have to be mentioned. And the management and the administration of the company. How the company is being managed, how the company is being administered by the board of directors. Clauses with regard to those should be included in the articles of association. Other things also you can include, but these 3 are a must according to section 13 of Companies Act number 7 of 2007. The articles of association set out in the first schedule of the Companies Act, which we refer to as the model articles, shall apply in respect of any company other than a company limited by guarantee, except to the extent that the company adopts articles which exclude, modify or are inconsistent with the model articles. So having model articles is not a must. Having model articles, using the model articles is not a must. If you want, you can draft your own articles and submit for the company. If you want, you can use the model articles that are there in the first schedule of the Companies Act. Other than, if you are a company limited by guarantee, you can't use the model articles given in the first schedule of the Companies Act. But any other company other than a company limited by guarantee can use the model articles that are given in the first schedule of the Companies Act. And you can use it, amend it, modify it as you wish and make your own company articles. The new Companies Act has made easier the formation of a company by allowing it to adopt model articles of association. So actually under the new Companies Act only we have this model articles of association. So for anyone who don't want to draft articles of association, the process is made easier. You can use the model articles of association under the new Companies Act. But under this there is something we need to understand called the ultra vires doctrine, the ultra vires rule, or we call it the ultra vires doctrine. Meaning of the term ultra vires is without power. Meaning of the term ultra vires is without power. Now, for the board of directors, shareholders to do the activities in the company. Power is given through the articles of association. So if they do something going over and above this power, or if they do something for which they do not have the power, those activities earlier would be considered as an ultra vires activity or activity done without power. Therefore, that activity will be void or not applicable. The ultra vires rule prevented companies from entering into contracts outside the objects or exceed the powers which were specified in the memorandum. The new act dispenses with this ultra vires rule. Now, why is the ultra vires rule important? It was there in the previous Companies Act. It's not there in this Companies Act, right? Basically, what ultra vires said was, companies have an objects clause. Usually, we put our objects in the articles of association. You can only do work which are consistent with these objectives. You can only do the work which are consistent with these objectives. You can't do work that are inconsistent with the objectives. Then we used to consider it as ultra vires those days. But now under the new Companies Act, they have dispensed with or removed this rule with regard to ultra vires, or the ultra vires doctrine is not there any longer. Therefore, there is no requirement. Usually we say company can do anything which is not illegal. Company can do anything which is not illegal, even if it is specifically not mentioned in their objectives. The objectives of the company were set out in the memorandum, and any act which was outside such objectives was held to be ultra vires, hence void. That was those days, because now we don't have a memorandum of association. No. In the earlier session, we discussed the list of documents that are required to incorporate a company. In that list of documents, we did not have a document called we did not have a document called memorandum. Why? Now the requirement for the memorandum have been removed under the new Companies Act. The requirement for memorandum have been removed. Earlier in the memorandum, having the objectives was a must, and all the objectives of the company were listed down in the memorandum of association. But now that the memorandum of association is not there, there is no big consideration on this ultra vires doctrine. Directors acting beyond their powers was considered ultra vires. Even earlier, if the directors acted without power or going beyond their power, it was considered as ultra vires or without power. Therefore, the action is void or not applicable. We consider as if the action did not happen, right? Void means as if it did not happen. Like in the case of Ashbury Railway Carriage and Iron Corporation Limited versus Ritchie. So, these case laws, at least try to remember it as the Ritchie case, right? At least try to remember one part of the name so that you can pull in some case laws, because you are given marks for providing case laws. The position was detrimental to the investors, because if any contract entered into by the company was found to be outside its scope of objectives, the innocent parties had no remedy under the law. But what happened now? The detrimental effect of the ultra vires doctrine was that investors did not want to invest in the company. Why? It was too risky. In case if the directors took the investment for something that they did not have the power to do, investor lost all their money, because the action was considered to be ultra vires or without power, therefore void. So investors were afraid to invest in the company. Therefore, under the new Companies Act, this ultra vires doctrine was dispensed of. In terms of section 13, the new Companies Act has granted the freedom to companies to carry out any business activity without being restricted to its objects clause. Under section 13, we still have an objects clause, but sticking exactly to the objects clause is not any longer required under the new Companies Act. Sticking exactly to the objects clause is not required under the new Companies Act, because earlier it was a detrimental effect on the investors. Investors did not want to invest in the company. Thereby, this ultra vires doctrine led to a situation that was unexpected, where investors were no longer bringing in business for the companies. So therefore, because of that fear, earlier what was ultra vires from the side of the company or from the side of the board of directors are now not considered as ultra vires, or the objects clause as mentioned in Article 13, as mentioned in section 13 of the Companies Act, is not companies are not bound by that objects clause. Still we have the objectives clause, but companies are not bound by the objectives clause. So remember, the ultra vires doctrine was of the previous Companies Act, not of the new Companies Act. Then the legal effect of the articles, another very important point, because they can give you a scenario and tell you to identify who is bound by the articles of association. So you need to have a very good clue about who is bound by these articles of association. So the legal effect of the articles, let's see how the legal effect of the articles work. We say that the articles of association act as a contract. We say that the articles of association act as a contract between the company and the shareholders themselves, right? I repeat, articles of association act as a contract between the company and the shareholders and between the shareholders themselves with regard to shareholder rights. Not with regard to any other right. It's only with regard to shareholder rights. That is, if a shareholder right is breached, shareholders can go to court against the company. If shareholders don't fulfill their duties towards the company, company can go to court towards the shareholders. Right? But this is only with regard to shareholder rights and nothing else. Now, especially when you take private companies, sometimes shareholders are also acting as directors, sometimes acting as employees. But they are not, right? Those employees, direct employee rights, director rights, for those you can't use the articles of association. Articles of association is acting as a contract between the company and the shareholders themselves with regard to shareholder rights only. So important points to notice here with regard to the legal effect. Articles of association is a contract. Articles of association is a contract between shareholders and the company, between the shareholders and the company with regard to shareholder rights only, with regard to shareholder rights only. How is it applicable in questions? We'll be discussing in the question series that we are going to do after completing this set of revision lectures. I've given you under the legal effect of articles, the articles of a company shall bind the company and its shareholders as if there were a contract between the company and the shareholders. So, articles of association act as a contract between the company and the shareholders. In particular, all money payable by any shareholder to the company under the article shall be a debt due from the shareholder to the company. That's why I told you, in case if there are any unpaid debts or if there are any unpaid share values that shareholders are supposed to pay to the company, it will be a debt under the articles of association. Shareholder is supposed to pay that money back to the company. So that's with regard to the articles of association. Mainly you need to know what are the contents under the articles of association. So that is basically governed under, if you remember, section 13. Section 13 said that there are three main things that must be covered by the articles of association of a company. That is the objects of the company, rights and obligations of the shareholders, and the management and the administration of the company. Then the ultra vires rule, which was applicable before, which is not applicable now, and the legal effect of the articles, that the articles form a contract between the company and the shareholders themselves with regard to shareholder rights only, with regard to shareholder rights only. So those are what you need to remember about the articles of association. With that, we are moving to the very last part that is covered under unit 2, that is about the company contracts, right? What are the different types of company contracts that companies have can enter into? The very first important type of contract is this pre-incorporation contract. Why is the pre-incorporation contract? This word is very important, pre-incorporation. Still the company is not incorporated. So, company cannot enter into pre-incorporation contracts. Usually, promoters enter into pre-incorporation contracts on behalf of the company. Promoters enter into pre-incorporation contracts on behalf of the company. What we must understand or what we must remember is that company doesn't bear an obligation under the pre-incorporation contract. Why? Company is not there. When the company is not there, can the company incur a liability? So therefore, actually it's the promoter who takes the responsibility on himself with regard to pre-incorporation contracts, because a company can't even ratify a pre-incorporation contract. What is the meaning of ratification? You go back in time and correct a mistake or give a power that was not there, right? That can't be done with regard to pre-incorporation contracts, because if you go back in time, company is not there. If you go back in time to the time that the pre-incorporation contract was made, as the word itself says, it's a pre-incorporation, before the incorporation. A contract entered into before the incorporation. A contract entered into before the incorporation cannot be ratified. Therefore, company is not liable under a pre-incorporation contract. I have given you there. A pre-incorporation contract is a contract entered into for and on behalf of the company before it is formally incorporated. So what we call as a pre-incorporation contract is a contract that is entered on behalf of the company before the company is incorporated. Like the example I told you before, right? Buying property on behalf of the company, like the process of buying property on behalf of the company. So when buying property on behalf of the company, usually the promoter will buy the property on behalf of the company. The promoter will buy the property on behalf of the company, and therefore, like acquiring property usually is a pre-incorporation contract. When a promoter buys property on behalf of the company, usually it's a pre-incorporation contract. Then franchising or distributorship agreements, like the business that the company is going to do afterwards, those things are also usually governed under pre-incorporation contracts. And then under the law as it existed prior to the New Companies Act, pre-incorporation contracts were not recognized and hence had no legal effect. Those days, under the previous Companies Act, pre-incorporation contracts were not allowed, right? Companies were not supposed to enter into pre-incorporation contracts. That is, contracts before their incorporation, companies were not supposed to enter into. And even if they entered into, it had no legal effect under the previous Companies Act. And also, very, very important, as I told you before, company cannot ratify a pre-incorporation contract. Company can't. Now, let's say company incorporation. For example, let's say company incorporation is on the 10th of May. Let's say company incorporation is on the 10th of May. A pre-incorporation contract have been entered into on the 1st of May. So, to ratify the contract, company should go back in time, right? Company should go back in time from the day of incorporation to the day of the pre-incorporation contract. As of this date, company is not incorporated, so company cannot ratify a pre-incorporation contract. So that was also said in the case of this 𝐂𝐜𝐿ner versus Baxter case. It was said in the case of 𝐂𝐜𝐿ner versus Baxter case as well. The New Companies Act, however, not only recognizes pre-incorporation contracts, but it regulates the process by making it a legal requirement to ratify a pre-incorporation contract within a reasonable time after the incorporation of the company. However, though this was not possible under the previous Companies Act, under the New Companies Act, it is said that companies can enter into pre-incorporation contracts, and though the company was not there at the previous date, under the New Companies Act, you can go back in time and ratify a pre-incorporation contract during a reasonable period of time. You can go back during a reasonable period of time and ratify the contract under the New Companies Act. So, pre-incorporation contracts were not valid under the previous Companies Act, but it is now valid under the New Companies Act. But regulates the process by making it a legal requirement to ratify pre-incorporation contracts within a reasonable time. So, you can't take all the time in the world. It should be ratified within a reasonable period of time after the incorporation of the company. Where a person enters into a pre-incorporation contract for and on behalf of a company, that person is deemed to give an implied warranty. So, especially now, I told you promoters enter into pre-incorporation contracts on behalf of the company. No? So, promoter is giving a implied warranty. Promoter is giving a warranty that the company will be incorporated within such period as may be specified in the contract, or if no specified period, within a reasonable time after the making of the contract. So, again, wherein promoter takes it upon himself that the company will be incorporated. Now this is a pre-incorporation contract. No, we are talking about a company that is to be incorporated in the future. But promoter is taking a personal liability and saying, yes, don't worry, the company will be incorporated. I am taking the liability, or I am taking the warranty for it that the company will be incorporated within a reasonable period of time or on the date that is specified in the contract. Not only that, promoter is also taking an implied warranty or giving an implied warranty that the company contract, the pre-incorporation contract, will be also ratified. The company will ratify the contract within such period as may be specified in the contract, or if no period is specified, within a reasonable time after the incorporation of such a company. So not only that the company will be incorporated, but also that the pre-incorporation contract will be ratified by the company within a reasonable period of time. That will also be given as a warranty by the person who enters into the pre-incorporation contract on behalf of the company, usually the promoter. So that's about pre-incorporation contracts. What you need to remember is, under the earlier act, pre-incorporation contracts were not allowed, but in the new act, pre-incorporation contracts are allowed, and companies given the opportunity to ratify the pre-incorporation contract as soon as the company is incorporated. Now, methods of contracting. We say that company is a legal person. Thereby, we say that the company has the power to act on its behalf and enter into contracts. We say that company has the power to act on its behalf and enter into contracts. So, what are the methods of contracting that a company would have? The legal requirements applicable for contracts that are entered into by natural persons are applicable to company contracts with the necessary modifications. Same rules that are applicable for a natural person entering into a contract are applicable for a company as well, but with the necessary amendments. For example, we natural people can hold a pen, sign a paper and enter into a contract, but a company don't have hands and legs, so company can't sign a paper and enter into a contract. No, thereby we have to do the necessary modifications, but the requirements are the same. An obligation may be entered into on behalf of the company in writing, signed under the name of the company. So of course company can enter into contracts under the company name, right? Usually when a company is entering into a contract, company name is what we use as one of the contracting parties. Very simple example, you know, when properties like these prime lands and all, when they are selling their lands, the seller, the vendor comes as the Prime Lands Private Limited. The company comes as the seller, just as an example. They come as the seller. And so the contract can be entered into by the company name. It can be signed by two directors of the company. Two directors can sign on behalf of the company. So two natural people appearing on behalf of the company, or where there is only one director, that director can sign. Or if the articles of the company so provide, by any other person or even a class of persons or one or more attorneys appointed by the company can be notarially executed. So in front of a lawyer, in front of a notary public, someone, either according to the articles, or two directors, or one director and the company secretary, or if there is only one director, that director can sign on behalf of the company where the company seal is affixed. To show the signature of the company, I taught you all about the common seal of the company under the first unit. To show the signature of the company, we place the common seal. To attest the common seal, either two directors, one director, director and secretary, or anyone who is appointed under the articles of association will sign in front of the notary public. That is what we say as notarially executed. Where an obligation is required by law to be in writing and signed by the person entering into it, person acting under the company's express or implied authority may sign on behalf of the company and enter into such obligation. So typically it's the directors or the company secretary or anyone signing on behalf of the company. Important word is on behalf of the company. They are not taking a personal obligation. They are signing on behalf of the company. And because the company is a legal person who don't have hands and legs, someone is acting on behalf of the company to enter into contracts. That's about the method of contracting. Then now we say, oh no, directors, officers, agents of the company can enter into contracts. How does their authority work? A company or a guarantor of an obligation of the company or any person claiming under the company cannot assert that the articles of the company have not been complied with against any person who has dealt with it and acquired rights from it. Now a director signs under the company seal. Later when a problem comes, director says, no, I didn't have the power under the articles to sign this particular contract. Therefore, that the third party can't sue the company or sue the director. You can't do that. Why? If you are signing under the company seal, you should know if you have the authority or not. The third person is not supposed to find out about it. The third party cannot be held liable for a problem inside the company, and after you sign on behalf of the company, you can't get away with that obligation. You will have signed on behalf of the company and that obligation stays. They also cannot assert that the person named in the most recent notice filed under section 223 or annual return delivered under section 131 are not the directors or the secretary of the company. After you sign under the company seal, you cannot come forward and say that you don't have the liability or you don't have the responsibility or that you are not the appointed official. Cannot be said. If you sign under the company seal as a director or any other officer or agent of the company, you are liable on behalf of the company. You can't say that you don't have the authority. Where a company holds out a person as a direct officer or agent of the company, it cannot assert that such person has not been duly appointed or does not have authority to exercise the powers and perform the duties. As I told you earlier, third party have no liability or responsibility to find out if this particular director or agent or anyone who is signing on behalf of the company, whether that person has the particular authority or not. So if you are signing as a director, agent or any officer of the company, you are taking the liability to find out if you have the responsibility or if you are appointed as the rightful person to sign this particular document. A company also cannot assert that a document issued by any director, the secretary of the company or any officer or agent with actual or normal authority to issue such document is not valid or genuine. So even a document that has the company seal, bearing the company seal with signatures of a responsible officer, company can't say that the company is not liable for that sort of a document, that the signatures are incorrect or it's not the particular signatures that should be there. It's irrelevant. Because the third party have no particular requirement to find out whether the people signed has the authority or not. Right? Even the third party is not supposed to go and take the annual returns of the company or form 1 or articles and check whether these people have the authority. They don't have to do that. Third party don't have to do that. Obligation is on the company. This is an area that an extremely good creative question can be formed, right? They can usually give you a scenario saying, okay, this person says that this sort of an issue is there. Right? Have taken a document from a company, submitted it at another office. Now the previous company who gave the document says that they are not liable. What is your legal implication? Legal implication is this. The directors, officers or agents of the company, after entering into contracts or signing a document on behalf of the company, later cannot deny their authority. Later cannot deny their authority or say that they do not have the authority. That is what we call as authority of directors, officers and agents to enter into contracts. Next one, the Indo management rule, very much connected. These two are very much connected. The Indo management rule and this authority is very much connected. Indo management rule, the authority of directors, officers and agents says that they have a liability to find out if they have the power to sign it or not. Indo management rule or the Turkwan rule says that third party do not have a liability to find out whether these particular officers of the company have the powers or not. So actually this is the positive aspect of it, that the directors, agents, officers have to find out if they have the power. Indo management rule or Turkwan rule says that third parties don't have to find out if they have the power or not. Under the common law, a person acting in good faith and without knowledge of any irregularity who is dealing with a corporation need not inquire about the formality of the internal proceedings of the corporation, but is entitled to assume that there have been compliance with the articles and bylaws, right? If I am a third party, I go into a company to sign a contract with the company. Company has put in some of their officials to sign on behalf of the company. I don't have to ask for company resolutions or form 1 or form 15 to check if this particular party have the power or not under the 𝐶𝐿 rule. Why we call it the 𝐶𝐿 rule is this was established in the case of Royal British Bank versus 𝐶𝐿. That's why we also call it the 𝐶𝐿 rule. So under the 𝐶𝐿 rule, third party don't have a liability to check any internal proceedings of the company or to find an irregularity in the internal proceedings of the company. A person dealing with a corporation has no obligation to ensure that a corporation has gone through any procedures required by its articles, bylaws, resolutions, contracts or policies to authorize a transaction or to give authority to a person purporting to act on behalf of the corporation. Third party just have to go and represent the third party. Third party don't have to find out if the company has given the authority in the rightful way for these people to sign on behalf of the company. Why? It's the company's responsibility, it's the director's responsibility, officer's responsibility, agent's responsibility to find out if they have the power or not. Indo management rule or the 𝐶𝐿 rule says that third party don't have to find out about it. Third party just can, take any document or a contract as they sign it and give, knowing that they will have the authority. Third party is not supposed to find out whether these directors, agents, anyone who is signing on behalf of the company, whether they have the required authority or not. Constructive notice. Constructive notice is a legal concept that signifies that a person or entity should have known, or as a reasonable person would have known the fact even if they have no actual knowledge of it. Now let's say third party particularly knows that this particular person don't have the authority. Sometimes it might be in public domain. Now, for example, let's take the president of a country, simple example. Let's take the president of a country. When the president changes, usually constructive notice, entire country usually knows that this is not our president any longer. So if you have an appointment with the president and when you go, it's not the current president that is seated there, then you know that this person is not the president. You know that this person don't have the power. What will happen in that sort of situation? The Companies Act specifically dispense the concept of constructive notice in terms of section 22, where it states that a person will not be affected by or deemed to have notice or knowledge of the contents of the articles or the company's documents merely because it is delivered to the registrar for filing or that it is available at the company's office for inspection. Now usually then came across the situation, okay, what if the third party knew? What if the third party had constructive notice? We haven't given notice, had constructive notice, gotten the knowledge that this particular person don't have the power to sign on behalf of the company. What if the third party knows about it? That was the question. What if the third party knows about it? But then Companies Act came out with their section 22 saying still, they dispensed of the requirement of constructive notice. Even if you have constructive notice irrelevant, you can't put the liability on the third party. The directors, agents and officers of the company have to find out whether they really have the authority or not. To enter into contracts or to sign on behalf of the company. As in the Indo management rule or the 𝐶𝐿 rule, third party has no liability to find out about it. Even if it is constructive notice, that is also irrelevant. Still third party is not supposed to find out whether officers of a company have the responsibility to sign on behalf of the company. That was about constructive notice. So with this Indo management rule, 𝐶𝐿 rule and the constructive notice only, your second unit ends. So the incorporation of a company unit ends there. And after that I have done a past paper analysis from the December and June-July question papers of 2023 and December and June-July question papers of 2022, as little analysis as to what type of questions have been asked. Further on these questions will be discussed at the paper discussion series that we will be doing after this lecture series. After the lecture series, we will be doing a online paper discussion series. At that paper discussion series, these questions will be discussed at large, but the basic knowledge that you require to answer these questions have been given in this set of slides. So if we go to the beginning once again, if we go to the beginning once again of this set of slides. So the second unit starts with the different types of companies. We started with the different types of companies. Then we moved on to, after discussing the different types of companies, we moved on to discuss about the incorporation of a company, where we started with naming of a company, and we went on to discuss the documentation that is involved in the incorporation of a company. And under a separate set of lectures, we started with the promoters. We discussed the duties and how payments are done to a promoter. Then we move on to the contents of the articles of association, its contents, how ultra vires doctrine works, and the legal effect of the articles. And we ended with the different types of contracts that a company enters into, from pre-incorporation contracts, earlier not being ratified, now being ratified, and who can sign on behalf of the company, and the Turk Bond rule and the constructive notice. So with that, the second unit has also come to an end. I'll meet you in the next lecture series with the third unit's revision.